name. Amen.
Amen. Amen. Thank you. Thank you very much, Chairman, Law Reform Commission, for the opening prayer. And let me at the outset welcome you on behalf of the Bills and Legislation Committee inquiring into the Mineral Resource Bill 2025. Thank you for the opportunity for you to appear in person before my committee. We are very, very much grateful for that. You are, Chairman, familiar with the Bills and Legislation Committee privileges. Please be assured that they are still there, and for you to make your presentations upon them to the committee. I have here on my right the Leader of the Official Opposition, Honorable Matteo Wale, and Member of Parliament for Auckland. The Uncertain Secretary is also present for their duties as far as the inquiry is concerned. Without further ado, Chairman, I will now hand you the mic for you to make your presentation to the committee. Thank you very much.
Thank you very much, Chairman Bills and Legislation Committee and Committee Member Honorable Mati Wale for Auckland and Leader of Opposition. Thank you for the committee's extension of this invitation to come and physically appear before the committee to share our views in relation to this bill. We have identified certain areas that we wish to raise on behalf of the Law Reform Commission as for purpose of introductory purpose. As you know, my name is Philip Canerara, the Chairman of the Law Reform Commission. So for this morning, I will share with you our views on the bill that is before us, the Mineral Resource Bill 2025. Those views we share just to help the sponsoring ministry, if they consider it as appropriate or relevant, to take it for further consideration. This is something, the sharing in relation to ensure that we have in place better laws, better bills to come before Parliament for enactments. So that is the basis or the context in which I appear to share the views. Obviously, we always support the government bills because those are relating to government policies, and in this sector, the mineral sector. So without taking much of your time, I will now go through our submission. So at the outset, as I say, we always support government bills, and that's because it relates in relation to government policy, the GNAT policy in relation to this sector, the mining sector. But there are some views that we wish to raise to the committee for consideration. So I will go direct to the views. So if you can, I hope you have with you our written submission. So if we, on page number 2, on clause 5. So clause 5 is something that we wish to raise. We raise why subject the act at the moment this bill to this Petroleum Exploration Act, which I think it's need of a review too. So our point is basically, if we are to subject any act, I think it's better to just to clarify the specific parts or the specific provisions, because those, when we have a general subjective subjects on provision, there might be other relevance in that act. So it's more preferable or recommendable to subject and with specification. So that's the view we have, and that's same to clause 6. Instead of having this or this bill or this law will subject to this these acts, we specify the setting specific parts or the provision, specific provision. That will be very clear.
So this one here, clause 6 here, for example, it gives examples, list logot acts here.
Yes.
But obviously, they're only examples.
Yes.
So it's not an exhaustive list.
Yes. So at the moment, the obligation under this act, so the act has effect subject to other acts that may affect, they use the word may affect the rights and powers given in this act or obligation and functions imposed under this act. So they note these examples. Yes, it's not an exhaustive list because they did. So it means there might be other acts that but our view is if we are to subject, it's better to even if to subject to certain laws, as we often argue, those provisions might be relevant in the context of that law. So that's the reason we always say you subject with the specific provisions or sections. Yeah.
So why would they have framed it this way, clause 6 here? It sounds to me like a lazy kind of approach.
I'm not sure.
Maybe by breaching what Narwan, so you put this no in case.
So it's something for the sponsoring ministry to respond to. I do not have any view on that. Yes, so that's for clause 5 and 6. Clause 7 is where we wish to make a submission there on too. It's relating to the ownership of minerals. So at the moment, as we see in the bill, it have the ownership of mineral vested in the people and the government of Solomon Islands. So for us, it should just stop there instead of making all these other further provisions. So we have that provision like that, and then we, in our next point, as we say in clause 7.2, we can then provide for that the government on behalf of the people and the government and the people should work together to deal with the mineral resources. So in that way, you are getting people involvement in this sector, on the exploration or the extraction of the minerals. Because at the moment when we say government and the people, and when we have the exclusive regulation or dealings with the minerals basically by the state, the people do not see them as part of it. And to make it, because people are not actively participating with the government in relation to the minerals. So we think that yes, we put the government and the people and the government. The people here we should emphasize is the land owning groups, where the minerals are found. And the government there, I think there might be some argument that we should leave out the government in relation to this ownership. But for us, we see the government to be with the people, especially in relation to control the developments, especially in relation to environment. Because if we just allow the people as the complete owners, and they can do anything with that resources, even the nearby communities or tribes where mining activities happen, they will be disadvantaged. So we need government to be together with them, work on this thing, this mineral together, instead of just the people themselves. So that's why we think the people and the government together, it's still okay. But then when we, as in our other parts, when it comes to, we might do, because we recommend to do away the idea of access agreements. Because access agreements, basically, we are just perpetuating the thinking, the common law thinking, the common law were developed around 1568, where there was a case on the case called the case of mines, where it says that the minerals, valuable minerals like gold and silver, can be only owned by the king or the queen, or only the royals can own that. So therefore, it's the crown will be responsible for the ownership of those minerals. And because of that, so in England at that time, minerals, mostly this gold and silver, owned by the crown. And in order for the investors or the developers to enter into the land, they need this access agreement, because this access, the service rights belong to others, especially where those lands are not belong to the crown. They need to deal with the private individuals where they own those. But in cases where the land is also owned by the crown, then no problem, because they will just basically crown service, crown the minerals. So common law in those days, they have it like they regard as two estates in order to get to the minerals. So what the first estate is the service. They deal with the private individuals in cases where private individuals have ownership to those land, and then go down to the minerals, which is if it's gold, that's crown. They will deal with it. So when we continue to have it here, then it raises a question. So really, we are not recognizing our people as customary, our people, where they live, their land, and down under, what's under, the ownership is there with them. So if we can look through our history, people have been raising that. We found out that in 1974 there was a special select committee on lands and mines where involved some members of the assembly at that time, where they involved dealing with, and people are talking about this. There shouldn't be any law as to 6 feet. But this issue about 6 feet in law, I did not come across anywhere in the common law where they talk about 6 feet. But in Solomon Islands, 6 feet, it's something that everybody talks about. Because we did some consultation on the foreshores in the past, and many people raised the idea of 6 feet. They say, okay, people only own up to this, and then below 6 feet, it's the crown. But I don't know where they get that that thinking from, because even in common law, you don't find anything. But in common law, the case I cite, the case of mines, it relates to mineral ownership, where it's the royals, they own the gold and the silver. And so there you can see also the reason why we have this royalty attached to that, because payment of using those minerals were owned by the royals, the king or the queens.
What's the practice in other Commonwealth jurisdictions or common law jurisdictions? Australia, PNG, PG?
I did not do any research in those areas.
Because we asked this question and got law, legal drafting law AG, so with reference in no common law.
Yeah, so for me, my findings, my common law only goes back to the case of 1568, the case of mines, where they, as they call, we talk about where recognizing that for valuable minerals like gold and silver, it's only the royals who will own them.
So other minerals less valuable?
It's valuable can be owned by others, but then over time, as we see from our laws, they got to get them all in. Like in our 1969 minerals ordinance, everything, all minerals in the